Laura is a Texas AgriLife commercial horticulture extension agent for Tarrant County and an ISA certified arborist. Yay, Laura. She provides informal education programs and problem-solving services to all aspects of the commercial horticultural industry. Prior to taking on her present position in March of 2008, she was with the University of Florida Extension for 7 years. She's a sixth-generation Texan, graduate of Eagle Pass High School, and earned a Bachelor of Science in Horticulture and a Master's in Education from you-know-where, Texas A&M University in College Station. So again, welcome everyone, and let's get going.
Okay, thanks. Well, I am going to talk to you today about pesticide license record keeping requirements. And I know you are very excited about hearing about that because it's so interesting. I think, John, do you know how to, my face is covering up my slide on my...
No, you're fine. Don't worry. I'm watching what they're seeing, and you're in a little box above. In fact, if they want to move make your face bigger or the slides bigger, they can slide that gray bar up and down. But don't worry about it. You look great.
Okay, well, I'm going to slide my face off of my screen. So
there you go.
There you go. Okay, that's fine then. All right. So I'm going to slide my face off of my screen and just talk about laws and regs record keeping. This is a laws and regs CEU for you, and you'll see why you need that as we go through this. But record keeping really is not the most fun part of research or anything you probably do, but it is a really important part because it does, from a legal standpoint, protect you. And from an informational standpoint, it also really can help you do a better job as a pesticide applicator. Because you'll be able to know what you did that other time and whether or not it worked. So record keeping really is useful for more than just fulfilling the requirements of the law. So let's carry on here. All right, so here's what we're going to talk about. We're going to talk about the types of pesticide licenses and the records that are required for each to hold and maintain your license. And then we'll talk about pesticide applicator records, the records of the actual pesticide application. And then we'll talk about pesticide application complaints, how that process works. Gene asked me to include that. He thought that was something that people often had questions about. So we will include that at the end. I think I'm going to go, in the interest of time, I'm going to go through the middle part almost completely, go ahead and do the complaint part, and then go back to actually filling in the applicator record form, because that could take a little bit of time, but we'll see how it goes. All right, so types of licenses and records required. This is a picture of a whole bunch of horticulture agents and specialists. And I put this in here because we all hold the same kind of license, which is probably different from the one you hold if you're a commercial applicator. We're all non-commercial political applicators. We're going to talk about all those different licenses, the kinds of CEUs you have to get to renew them, and how they work. And I hope that you can find your horticulture extension agent in this picture. All right. Commercial versus non-commercial. So a commercial applicator is a person who operates a business or is an employee of a business that applies pesticides of any kind on the land or of another person for hire or compensation. So a couple of things about commercial application. You're not on your own property and you get paid. Those two things are key to remember. Now, non-commercial applicants are not required to be licensed as commercial applicators. What does that mean? I'm a non-commercial applicator. Why am I a non-commercial applicator? Because I work for a political subdivision. So I work for an entity of the government or the state or an educational entity. The other big group of non-commercial applicators work for properties that are not farms, but do care for a large landscape that is owned by an entity, and they do not apply pesticides off of that particular property. So a big example of this would be somebody that works at a golf course. If it's a public golf course, they could be a political applicator, but if it's a private golf course, they could be a non-commercial applicator. Someone who applies pesticides in a cemetery, for example, and that's, you know, where they work, that's their job. They could be a non-commercial applicator. A non-commercial applicator can get paid as a part of their job, but they do not hire out onto other people's property and apply pesticides. So the commercial license, it costs $180 a year. So it's more expensive than a non-commercial license. It expires 1 year from the date of issuance or on the last day of February. If your license is an old license, you've had it for a while, it probably expires on the last day of February. When I started working here in Texas 15 years ago, almost everyone's license expired on the last day of February. But now, 15 years later, that's kind of unusual. So that is the reason that there are so many pesticide CEU programs in February, because it used to be that everyone's license was going to expire and they all said, let's do a program. But nowadays, your license can expire at any date in the year, at the end of the month. It's also, to renew, you've got to obtain 5 continuing education units each year, and that's the same for both the commercial and non-commercial licenses. The other thing about the commercial license is you must attest to the existence of adequate financial responsibility, which generally means you must carry liability insurance. So insurance, they can get it under a business or an individual policy, and it has to be adequate to cover $100,000 of property damage, $100,000 of bodily injury per person, and an aggregate of $200,000 of bodily injury and property damage for each occurrence. The cost of a non-commercial license is a little cheaper. It's just $120 a year. It expires 1 year from the date of issuance, just like the others, and you must obtain 5 continuing education units each year. Now, the non-commercial political license, on the other hand, is even cheaper. It used to be free, but now it costs $75 a year, and the same expiration and CEU requirements are applicable. So here's my license. You can see that it's a political pesticide applicator license. You can see that it expires on May 31st of 2023. Couple of things to notice are the license number. That's very important. You should always provide your license number when you want to get CEU. That is a barcode of your license number. If someone's able to scan barcodes at a CEU program, they can just enter your license number automatically. And you'll also notice that my card is yellow. If you have a blue card and you're listening to this, you probably want to just stop listening right now, because I don't think that structural CEUs were approved for this talk, and blue cards are held by structural pesticide applicators. All right, so the CEU requirements. The reason we're talking about this right now, right here, is that you have to get 5 CEUs each year. And Dr. Apple's going to talk to you about integrated pest management, and he's also going to talk to you about plant pathology, and he can talk to you for 4 hours about that, and you can get 4 CEUs, and that'll be great. And you can get one of these special ones, which is the integrated pest management. But then you've also got to have either laws and regulations or drift minimization. So that's why we're doing this. Record keeping for CEUs is a big part of, it's not a hard part, but it's a big part of your record keeping in order to maintain your license. You are required to keep a copy of certificates earned for each of the CEUs you earn for an entire year after the license is renewed. the person who grants you the CEUs, in this case that'd be ISA, and that'll probably be Megan. She'll have to put your license number in and the CEUs that you earned, but you're also required to keep that certificate. If you get inspected, they will look at your certificates of completion for your CEUs, and if there's any discrepancy, if there's any question, if something went wrong with the input of your license number, or let's say she typed the wrong number in, if you have that CEU, that is your proof, that CEU certificate, that is your proof that you completed the CEUs. So you do have to keep those. They always have to have the course number, the CEU type. You can see right here, this is the course number for this particular program. This was an IPM CEU. They also have to have the date that it was issued, the location. So this is a web-based CEU, but it came from my office. And it must be signed, and it doesn't have to be a, it can be an electronic signature, but it must be signed by the person who is saying, yes, this CEU was earned. So here's one that I received. Here's one I earned. It came to me as an email. That's fine. You can see, though, that it has the course number here. It should, yep, it has the dates down here that I earned these CEUs. It has a signature from Katie Flowers with the Texas Turfgrass Association, and it shows all the CEUs that I earned attending that conference. So was this enough for me to renew my license? Yes, it was. Actually, one more than I needed. So no, exactly 5. You're right, exactly 5, but I didn't have to have all 3 of these special categories, but I did get, I'd only have to have 2 of them, but I did get all 3 of the special categories that year. All right, do I need to keep that certificate? Yes, I do. I need to keep that certificate until I get a new license in 2023. Why is that? I'm gonna go back to it. Whoops. See, it was issued in 2021, so that was how I renewed my license this year. And then I've got to keep it for a whole entire year after that renewal. Truth be told, I have a whole file folder full of certificates of completion. I don't ever throw them out, but you can throw them out 2 years after you've renewed your license. All right, moving on. And if you have questions about, I know that they don't want to stop and do questions and do more questions, but if you have questions about the CEU requirements, basically it's 5 CEUs, how long you have to keep those records, which is a year after you renew your license, and the cost of the different licenses, and why you would want one or the other, you can definitely put those in the chat and we'll answer them later. Okay, onward to pesticide application records. This is the big part of this talk. And so Gene might recognize this pesticide application because he did it. This is my live oak tree at my farm. You can see that we're applying Alamo propiconazole to this tree for oak wilt. So this is the application that we'll use kind of as our example when we get to that. Oops. All right, record keeping. Here's the requirement. Whenever you see the 76 point something, that's the law, the Texas law that lines everything out. So this is what's required in the record keeping standards. Commercial and non-commercial applicators have to maintain records of all pesticide applications, and that includes general use products. And I'll talk about general use, restricted use, and state limited use products. But any pesticide you apply, you are required as a commercial or non-commercial applicator to keep a record of it. Private applicators, which is applicators on a farm or in a forest, somewhere in the production of plants for sale, they don't have to keep records of general use products. They only have to maintain records of restricted use pesticides, which everyone in the whole entire United States has to maintain, and then the state regulated pesticides. It's a good idea for private applicators to maintain pesticide application records, but they don't have to legally because they're just on their own land, I guess, is the main thing. And there's less likely to be a complaint. All right, so classification of pesticides. 3 types. General use is something that anybody can purchase and apply. Nowadays, a whole lot of our products are general use products. Most new products that come out are general use products. There are just a few restricted use products being developed. There are a few more that are still on the market because they're old products that are used, but they're still restricted use. And then state limited use, well, and sometimes the EPA does move a product from general use to restricted use if there's information about its usually potentially negative impacts on the environment. Sometimes it might be human health impacts that weren't immediately evident, but usually it's environmental impacts. So state limited use is TDA's special list of chemicals, and these are only limited in use when they're sold in larger containers. So if the container is small enough, under 1 quart or 2 pounds, you do not have to have a license to purchase and apply these. However, if the container size is larger than that, you do have to have a license to purchase and apply these. You're probably thinking, well, why? What's special about those? So here's the list of them. So what's special about them? Well, almost all of them, all the way through quinclorac, are one type of pesticide. And the type that they are is herbicides, right? These are some probably familiar names to you, like dicamba, 2,4-D. All of these are herbicides. Most of them are auxin type herbicides, so they have, or photosynthesis inhibitors. Some of them are photosynthesis inhibitors, but they have that action on plants where they will distort growth. Obviously, they're herbicides, so they will kill plants. They're also all things that will kill a particular plant that is grown in the state of Texas, which is cotton. A lot of these products are state limited use because of their potential negative impact on valuable crops like cotton. Also, grapes are another crop now that's very valuable, that's damaged by dicamba. So that's why they're limited. In certain counties in the state of Texas, you have to get a permit when you're going to apply these. They're mostly counties where cotton is grown. So Tarrant County, where I work, is not a state limit, a county where these products have to be, you have to get a permit to apply these. These last two right here, the M44 and LPC. LPC stands for Livestock Protection Collar. These are both cyanide systems for killing predators. So they're very limited in their use, probably not something you're going to use in tree care, but those are also state limited use products. All right, so how long do you have to keep application records? Now, we said that you've got to keep CEU records for 1 year after you renew your license. Application records, it's a little simpler. You just keep records of applications for 2 years after the date of application. So whatever that date is, if I applied something on November 9th of 2020, I can throw that record away today because 2 years has passed. If you want to, you can keep those forever, of course, but that's the requirement. You must keep them for 2 years. Upon written request, a licensee shall furnish the department a copy of any requested records pertaining to the application of pesticides. Now, why would they request that? There are really 2 reasons that they might ask you for records. One is that they're investigating a complaint, and so we'll talk about that a little bit later, but if there is a complaint, they can request your records and you have to provide them. The other thing that may happen is that, well, they're doing, I forgot that one, they're doing a regular inspection. They'll look at your records during a regular inspection. But the third thing is sometimes they just do a correspondence audit of your records. So if they do a correspondence audit, they'll just send you a letter and say, please send me your CEU certificates for the renewal of your last license and all your application records for the last 2 years. So that's something that they can request. Sometimes they do that. Okay, so how do you fill out that form? There are 14 required elements that must be recorded. Now, they don't have to be on any particular kind of form. You can set this up. You could set up a spreadsheet for it if you wanted to. You can use the form that the Texas Department of Agriculture provides, which is obviously going to have all the things on there, but you don't have to use that form. If there's another easier way for you, there are some apps, commercial apps that will allow you to input these into a form on your phone. You could use something like Microsoft Forms to create that yourself. The way you keep the information is up to you, but the kind of information that you have to keep is prescribed by law. So we'll start at the top. The date's pretty easy to understand. The beginning time for the application is also pretty easy to understand. At what time did you start applying that pesticide? The name of the person for whom the application was made. So that's typically your client or your customer. The location of the land where the application was made, stated in a manner that would allow inspection by an authorized party. So that's typically pretty easy. Most of the places where you might be providing tree care, where there's an address that you can use. Every piece of property now that has a dwelling on it has a 911 address, but sometimes you might be applying pesticides in a location that are not on a road, not easily described by an address. So you just have to come up with something. GPS coordinates are okay, but something that will allow someone else to find that particular site where you applied the pesticide. Then for each pesticide applied, you need the product name, the product EPA registration number, the rate of product per unit, the total volume of the spray mix, dust, granules, or other materials applied per unit, and the name of the pest for which the product was used. So for the product name, that should be pretty easy. The EPA registration number is never going to change for that product, so you can find that on the label, but once you've got it, if you're using like a spreadsheet system, you can pre-fill that. That's easy enough to know. The rate per unit is a little bit more complicated. That's going to be ounces per gallon, or it might be pounds per acre. But it depends upon what kind of pesticide you're using. The total volume would be what you actually mixed up and applied, and then the name of the pest for which the product was used. So whenever you're applying a pesticide, you're going after something. It could be a particular pest like emerald ash borer, or it could be something as general as broadleaf weeds. In turf, whatever it was that you were going after. All right, now the site treated. The label must allow application to that site. So if you're treating in a residential landscape, that label must say that it's okay to apply in that site. If you're treating in a pasture, the label must say that it's okay to apply in that site. That's something that is a little bit confusing for people because oftentimes the same active ingredient might have a different brand name, could be labeled in different ways for different sites. A pretty good example is commercial landscape and residential landscape. They're the same. I mean, grass, trees, plants, they're the same, but the difference is, well, people live in this one environment and people kind of just pass through the other one. And sometimes you can use something in a commercial landscape that you can't use in a residential landscape. So the label must allow application to the site. That's one of the biggest restrictions in labels. Biggest things that you need to make sure is correct. Then the total acres or volume of the area treated. Most of the time that's going to be like in square feet, but it could be like one tree or two trees. wind direction and velocity, except for those applications made indoors. So even though you may be doing something like injecting a product into a tree, you still need to record wind direction and velocity and air temperature. And those numbers are easy to get nowadays. Everybody has a phone, everybody has an app on their phone. You can easily get those numbers, no problem. The application method or the type of equipment used to make the application. The FAA N number for aerial application equipment, most of the times you're not going to be doing that, so you can just X that one off. The name and department pesticide license number of the applicator responsible for the application. And if there's a different person actually making that application, their name also needs to be on the record. The spray permit number applies to regulated counties and regulated herbicides. As we kind of discussed in the state limited products, that you just need to know if the county you're in is a regulated county. And if so, then you're supposed to get a spray permit to apply any of those regulated herbicides on that state limited use list. And finally, documentation to verify training of persons working under the supervision of a licensed pesticide applicator. All right, so if you're the licensed pesticide applicator and you're not actually applying the product, there are 3 ways that you can document that the person that is applying the product has been trained. And the 3 ways are the affidavit of, what's that called? Affidavit of supervision. Affidavit of supervision. That's one, and there's a TDA form for that. And then the other way is that you can maintain a signed copy, signed by the person who applied, of the pesticide label. The idea being that you went through the pesticide label with that person and got them to sign it after they looked through that label. The problem with doing that one is, well, in my opinion, is that you would have to keep all the labels for everything. If you only use one product all the time, it wouldn't be such a big deal. But probably the affidavit of supervision is going to be more efficient, just simpler, less stuff to keep up with than signed labels of all of the labels that you've trained the person on. And then finally, the other way, the third way, is not really available to you, but that's a worker protection card number. Worker protection standard applies to agricultural workers. So if you're not working in an agricultural situation, which would be, you know, in the tree world, that could be a forest or a tree farm. WPS card is not really going to be the way to go. Okay, a couple of other things. Copies of records of applications must be submitted to the department if they request them. And then the record of each application should be legible and in a format that clearly identifies each specific item of information. So you don't have to use their form, but you do have to identify each and every piece of information. So it has to be labeled. All right, here's an example of an old form that has most of the stuff on it. Going up here to the top, application date back in 2005 when we still had Ag Commissioner Susan Combs. That was a long time ago. The time that they started the application, the name of the person for whom the application was made. So this is blank right here. Why is it blank? Is it okay for it to be blank? Yes, because if I look at this, I'm going to assume that Joe Self was applying it on his own rangeland here. He was not a commercial applicator, probably a private applicator perhaps, but he did not apply this application for someone else. So here's the location of the land. The site treated as rangeland, the wind direction and speed, the product trade name, the EPA registration number, which you get right off the label. The target pest in this particular situation is the prickly pear cactus. The rate of product per unit. This herbicide was mixed up at the rate of 1 quart per acre. And then you see down here that Joe treated 3 acres. And did Joe actually treat this? Nope. So you can see that the actual unlicensed applicator's name is Pascual Hernandez. Then the total volume of spray was 25 gallons. So you can see 25 gallons per acre. So they actually sprayed out 75 gallons of product here. A little bit of additional information. Obviously, they did not apply this to the entire 3 acres. They applied it to the prickly pear in those acres. They did use dye and surfactant. So those are just kind of notes on that. Here's another one. This is a separate application. You can see that they did the rate of product per unit and the total acres treated differently on this one. The rate of product per unit on this time was measured in ounces per 100 yards, and then they treated 200 yards, which is interesting. So just a different rate and a different application area. All right, so here's a blank one. We're going to fill it out, but I think I'm going to skip that so that I can be sure to get through all the other information, and we'll come back to this. All right, so record keeping pitfalls, problems with record keeping. Well, what are they looking for when they look at your forms? What are some keys to that you're not completing the form? One thing they say, inspectors will say, is that people will not bother to actually record the wind speed. For example, today, what's our wind speed here in Fort Worth? I just looked it up. It's about 10 miles per hour. Most people can easily access that weather data now, so there's no excuse for not including that. But take the time to access it and record it. All right, so general supervision requirements. That means if you're the applicator and you're not actually applying the pesticide, what are your responsibilities? How can you supervise someone else applying the pesticide, and what do you need to know? Couple of things. The label can prohibit such applications. Sometimes a pesticide label will say that the product can only be applied by a licensed applicator. If that's a label requirement, then you must do it that way, because you must, if there's some discrepancy in supervisor requirements, the greatest degree of supervision shall apply. Sometimes a label will say, even though in general supervision does not have to be physically present, sometimes a label will say that the supervisor has to be physically present. So whatever the greatest degree of supervision is, that applies. All right, so general supervision. A licensed applicator cannot supervise someone whose license has been suspended or revoked. And why is that? Well, they've done something wrong if their license is suspended or revoked. So you probably don't want to be supervising them. So chances are you don't want to do that, but you can't. So don't even think about it. The other thing that's interesting is that the licensed applicator does not need to be physically present during the application, but must be available. Nowadays, it's really easy with a phone. Everybody has a phone. If you can have phone contact with the applicator during the application, then you can, not be physically present at that site. The licensed applicator is, however, responsible for the actions of the applicators under your supervision. So if something does go wrong, it's your license and it's your liability that's on the line. Okay, so this is what we call the Houston rule. Both the supervising licensed commercial or non-commercial applicator and the person under direct supervision of the licensed commercial or non-commercial applicator must perform applications from the same local office. The reason this rule was made was that there were branches of companies that did not have licensed applicators in all markets, I guess, or all local locations. So this rule was amended to prevent that. So you couldn't just have one applicator in one location in the state supervising unlicensed applicators all over the state making applications. So the exception to this rule is that if the licensed applicator is physically present during the application. So the licensed applicator generally needs to be in the same, though it doesn't quite say this, but to work from the same local location, even though they might be on a trip to Colorado or they might be somewhere else. They still have to have the same home base as the unlicensed applicator. All right, one more thing. The non-licensed applicator needs to be trained, and you have to prove that this person has been trained. The direct supervision affidavit is a good way to do that. I think I have it next. Yeah, here it is. This is a form that's available. You obviously don't have to use the form, but it does tell you what has to be on there. It has to be signed essentially by both the licensed applicator and the unlicensed applicator. And you have to have a date when this happened, and you have to have the licensed applicator's license number, address, and telephone. But you also have to cover the products that the unlicensed applicator was trained to apply. So whatever products those are, to list them all out, their EPA registration numbers, how they work, and where they're used. This is something that you can do once with a person. You can keep a record of it. It should be kept with your pesticide application records. But once you've done this and you've signed it and the applicator has signed it, that would be your proof that you have trained them to apply that product. All right, the complaint process. Does anybody recognize this picture? It's about 50 something miles, more or less east, southeast of here. This is the pesticide complaint that it's somewhat involved in the process, and it happened several years ago, but this is Greenleaf Nursery. It's not a tree farm, obviously, but they grow lots of different kinds of herbaceous perennials and annuals. It has greenhouse and outdoor nursery space. One Monday morning, the grower called me from Greenleaf, and it was Trevor Hilburn at the time. He called and said, I took the weekend off, which if you've ever been a grower, you know that usually during the busiest season, you probably don't take the weekend off. But he said, I took the weekend off. I came in on Monday morning and I just cried because all the plants looked like they had been blowtorched. And I said, really? So, you know, what happened? He's like, I don't know. The irrigation was fine. Everything was okay, but something bad happened. And so I said, you know, is there any cotton anywhere around your nursery? And he said, well, yeah, actually there is a field of cotton close by. And I said, well, it could be drift from the cotton field. And he said, well, what do I do? And I said, so call your TDA inspector and that person will take it from there. So he did. They did call the TDA inspector, who did go through the steps that we're about to go through. And actually the application had been made to the cotton on Saturday and it had drifted. And so the owner of the farm, of the cotton farm, actually purchased all the plants from Green Lake that were impacted by the drift. So that's how it all came down. I don't know if they suffered any kind of other problems from TDA, but you know, that was resolved in that way. So here's how it goes. If you have a pesticide complaint, if you think that something has been intentionally or unintentionally treated with a pesticide and it has caused a damage, like it's killed a plant usually, what you do is you contact your TDA inspector, and that inspector will contact the complaining party, that's you if you're making the complaint, and initiate an investigation. So the report is going to contain the name of the alleged responsible person, the name of the owner or the lessee of the land on which the application was made, the name of the owner or lessee of the land to which adverse effects are alleged, and then the facts of the violation set forth in detail. So the TDA inspector will collect all this information. They'll come interview you and they'll complete this report. This report has to be signed by the complaining party. So it's important to know that you can't make an anonymous pesticide application complaint. You must be willing to meet with the inspector and sign the complaint. So that's a safeguard for applicators because I think someone really has to be confident that they've seen something that they're pretty sure that something went wrong. It's not something that a person can just call a hotline or make an anonymous complaint about. Okay, then the inspector is going to follow up by notifying the person who may be charged with the adverse effects, and then investigate the complaint and make a full written report. So if you are on the of the application made end of the complaint, the inspector's going to contact you. They're going to ask for your pesticide application records. They're going to go through those records. They're going to inspect if they want to. They can look at application equipment. They can do anything they want. And then they're going to create a complete report based upon what they think has happened. All right, so what's next? Well, many times, in fact, in the majority of the times, there's actually no violation according to their records. Sometimes it's because they're unable to determine what really happened or unable to determine responsibility. So most of the time, in the majority of cases, there's no violation. They can also issue a warning. A warning would be just kind of like getting a warning because you were driving a little too fast, but you didn't get a ticket, but you're on notice that something kind of went wrong. Pay attention. Obviously, if you received a warning and then again the same problem occurred, the warning would be a record that this had happened before. They can assess an administrative penalty, which basically means that they can fine you, and they can and will. And then they can suspend or revoke a license or modify it in some way so that you can't be a pesticide applicator anymore. And they can, at the very worst case situation, refer the case to another state or federal agency. That would be when there's the suspicion that this could be a criminal case, like an intentional poisoning of a tree. That would be referred to law enforcement. All right, so basically, if you'd rather not be involved in the pesticide complaint process, there are some things you can do. You need to know the pesticide application laws. You need to keep good records. You need to read the label, make sure that you're applying the product legally, the pest and the site and the application equipment, everything is in line with the label and you're following those rules. You must, if you're going to supervise other people applying pesticides, you need to be really sure that you've trained them well and that they do things in the way that you've trained them. There's not a good excuse for not doing something safely. Those of you in tree care know that safety is really important when you're climbing and pruning. It's the same thing when you're applying pesticides. Those safety procedures, those precautions, PPE, all of those things are very, very important. You also kind of need to know your community, where you're applying. Be mindful of what's around your application site. Bodies of water are particularly important, but also are there schools? How do the neighbors feel about things? Is there an event going to be happening that might not be a good time to apply a pesticide? And then also finally, make sure that people understand what you'll be doing, when you'll be doing it. It's good to talk to people that can usually head off a lot of their concerns. All right, that's the end of the presentation. I noticed that I've kind of eaten up all of the required 50 minutes. I was planning to actually fill out the pesticide form with you all, but I guess we'll take Q&A instead.
Yeah, thanks, Laura. Jean is again we have some questions that come in from the
Great.
viewers. So Jean, you want to take it away?
Yes. The first question I have up is, do you need a license to treat the occasional stump with herbicide?
Yes, unless it's on your own property. Yep, you do.
So it's literally on your own property.
Your own home property or your farm, yeah. If you're doing that as part of your tree removal service, you should be a licensed pesticide applicator.
All right, and then the next question has to deal with deals with the difference between the TDA commercial applicator license must have the proper category for the area they are commercially applying in. Arborists must have a pasture and rangeland category in order to treat trees in said ag exempt area and not just the ornamental turf category.
Yeah, so the categories, a little bit yes and no. I would ideally, if you're going to be working in pastures and rangeland frequently, that would be great to get that category. It's going to be all about herbicides. That's what all the questions are going to be about. If you don't do that very often, it's very rare that someone checks that category on your license, truthfully. And that landscape maintenance category is a pretty broad one, that 3A category. So how's that for an answer? If you do it a lot, I would say yeah. But if you're just doing it once, you could probably consider it to be something that was sort of landscapey.
Okay.
I've never heard of anyone getting in trouble for having the wrong category. How's that for an answer?
It's not my question, so yes, I think it's a good answer.
Okay, I mean, really, I've never heard of that.
And then the last question on here, actually, can you go back to your examples? Because it says the example shows 1 quart per acre, but total use 25 gallons per acre.
Yeah, I don't like that example now that I looked at it. I don't like, let's see. Kind of, all right, so here the example shows
John,
one quart per,
back to,
oh, show my screen, okay, I'm sorry. Can you see it now, 1 quart per acre?
Yeah.
Is this what you're talking about? Okay, so this shows 1 quart per acre of Surmount, which is an herbicide that kills cactus. So the way I would interpret this, that's the label rate, right? 1 quart per acre. They mixed up in order to treat to treat this 3 acres, they made a spray tank of 25 gallons. And the rate, that's the total volume of spray. That's not the rate of application of the product. So they made a 25 gallon spray tank because the product would go out at 25 at whatever, well, you're spot spraying really, so it kind of doesn't quite make sense to write it this way, the acres, but this is the total area treated. They didn't necessarily put out this much. They mixed up a 25-gallon tank because 25 gallons is the amount to treat an acre. And so in that 25 gallons of water, there would be 1/4 of the product. But because it's a spot spray, which, you know, you're not applying it to the entire area of this 3 acres. They're just moseying around on 3 acres, applying wherever. Did that
Yes.
answer the?
Yeah, I mean, it got into the difference between what the labeled rate is versus what you mixed up.
Yeah, what you mixed up, which is the core of that, of the difference between those two things.
Yep. All right. See, the next question down is applying a tree injection in a state forest park. Would I need the license for the forestry?
No.
That was an easy answer.
Yeah.
Then where is the line between fungicides and fertilizers as far as required record keeping? For
So there's
example,
no.
can I finish this question?
Yeah, go ahead. Go ahead. I just wanted to.
Yeah. For example, some fertilizers have fungicidal qualities and do not require application records. Can we clarify this area of record keeping?
Okay, so if something is a fertilizer, it's got a fertilizer label on it, right? NPK and all the things that are on a fertilizer label, and no pesticide label on it, then it's a fertilizer. Even if you're using it in some way that's, you know, fungicidal, it's a fertilizer. Then you don't have to have a license to apply a fertilizer in the state of Texas. In some other states you do. If it's got any kind of official pesticide label on it, it's a labeled pesticide of any kind, then you do have to have a license to apply it.
And that's where almost every small landscape operation out there that sprays Roundup on the cracks in the sidewalk for you without a license is breaking the law.
It's breaking the law. Yeah, exactly. Someone has to have a license. Not every person who sprays Roundup, but someone has to have a license.